Okay, welcome everyone to this webinar. It's great to see so many folks attending. Before we begin, I'd like to offer some quick guidance for today's virtual event. This webinar is closed caption enabled, so if you'd like to see the captions, just click Show Captions at the bottom of your Zoom screen. Sometimes it's nested under More. After the presentation, we will have a live Q&A today. So to ask your question, you can just type it into the Q&A feature located at the bottom of your Zoom screen. We will read questions aloud and be able to answer them live today. You can input a question into the Q&A feature at any time during the presentation. Please note that this presentation will be made publicly available after today, and we will be posting it on our website at peer.org. Thank you for joining us today. And with that, I now invite Tim Whitehouse, our Executive Director, to say a few words. Tim?
Yes, thank you, Helen. It's wonderful to see so many people joining this webinar. I see a number of familiar names and as well as many people that I have not yet met. So thank you for being here with us today. Today, we're talking about whistleblowers and the extremely difficult journey they go on when they decide to call out government misconduct and the sacrifices they make in order to stay true to their values. Over the years, it has been an honor for me to work with so many public employees who have committed themselves to making this world a better place. One of those people is our first presenter, Dr. Kyla Bennett, Peer's Director of Science Policy. I'm sure when our paths crossed briefly nearly 30 years ago at EPA, Kyla never imagined they would cross again years later at Peer, but here they are. I hope for the better, Kyla. Kyla brings a strong science and legal background, incredible skills as an investigator, and experience as a whistleblower to her work at EPA. Kyla, thank you for joining us, and we look forward to your presentation.
Thank you so much for that introduction, Tim. Okay, so I have been working at Peer since 2001 for a very long time, but prior to my time at Peer, I myself was a whistleblower at EPA. So I want to talk to you today about what drives someone to become a whistleblower and tell you my story. Next slide, please. So I started out by getting a PhD in ecology and evolutionary biology from University of Connecticut, and my dissertation research was on a population of wild ponies on Assateague Island, which is off the coast of Maryland and Virginia. Next slide, please. During my research, I spent 5 years living on this island with these herds of wild ponies, and we had literally decades of research and reproductive data on these ponies. So we knew exactly, this is the stallion John. We knew who his father was. We knew who his mother was. We knew who his grandparents were. We had an incredible wealth of data. And unfortunately, the population of these ponies overlaps with both a state and a national campground. And some of the campers there were not too bright with how they dealt with the ponies. I observed people putting their small children, 2 years of age, on the backs of the stallions to take pictures, feeding them donuts, things like that. So there was a lot of wildlife-human interaction and conflict. And the National Park Service decided that in order to take care of this conflict, they would cull some of the herd. And the way that they were going to cull the herd was by getting a bag of chocolate chip cookies and shaking it. And whichever ponies would come for the chocolate chip cookies, they would put them in a truck and haul them off to either adopt them out or send them to the slaughterhouse. This type of disruption to a herd system would have been devastating to the animals on the island, but also to our decades of research and my dissertation. So both selfishly and for the animals themselves, I decided to fight back against the National Park Service proposal. And I realized that I didn't have the tools as a scientist to do that. So next slide, please. I decided to go to law school. And I went to Lewis and Clark Law School in Portland, Oregon, to get a degree in environmental law. Next slide, please. While there, one of the cases in my many environmental law classes that we studied was Sierra Club v. Marsh, which was a case in the 80s. This one's from 1988, but there are actually several of them, where the Sierra Club and other plaintiffs were suing the US government over a an island called Sears Island. Next slide, please. Sears Island is a 940-acre island off the coast of Maine, and it's totally undeveloped, and the state wanted to put a port there. After I got my degree, my law degree, I got a job at US EPA Region 1 doing wetlands permitting and enforcement. Next slide, please. One of my first cases at EPA, ironically, was Sears Island, because after all these court cases ran through this court system, the case was remanded back to the Corps and EPA to see if a permit could be issued for the port that Sears Island and the Maine Department of Transportation was trying to build there for decades. Next slide, please. The history of Sears Island is storied. In 1960s, there was a proposal for an industrial park. In 1971, there was a proposal for an oil desulfurization refinery. In 1975, a nuclear power plant. Then in 76, a coal-fired plant. And then finally in 1980s, a container port. Then there was a restraining order issued, but not before the Maine Department of Transportation illegally built a causeway from this undeveloped island to the mainland. And directly across the harbor from this undeveloped island, which was filled with great wildlife and wonderful wetlands and vernal pools and uplands and beds of eelgrass, there's a place called Mack Point, which was already a port, and we argued that the state should be putting the port there. Next slide, please. So Mack Point was clearly a good alternative for this point. It was already developed. It would have left Sears Island alone, but the development could have been right there. There was actually a railway that went to Mack Point, so it was a perfect place for a port. And I said that, and I realized that the building Sears Island for this port would not have complied with the regulations under the Clean Water Act. So I told my boss, the regional administrator of EPA at the time, that the project could not legally be permitted. And he told me to change my scientific determination. I refused. I was taken off the case, and I found Pure. And Pure was just an infant back then. Pure started in the early 90s. I contacted them in 1994. Pure immediately weighed in and filed an action on my behalf under the Clean Water Act. Within 48 hours, EPA had capitulated and put me back on the case, and the permit was actually denied. Next slide, please. Not only was the permit denied, but we were allowed to take an enforcement case against the state of Maine for the illegal wetland filling. They filled over 10 acres of wetlands, and they were fined, and they had to restore those wetlands. And actually, that's how I met Tim, our executive director, because he was the one who was working in Washington, D.C. at EPA and helped push through this enforcement case, which I thought was really important. Next slide, please. Ironically, Sears Island is once again one of my cases. I was contacted a little over a year ago by federal employees who said that they're back again, and Maine DOT now again wants to build a port on Sears Island, this time for wind turbine blades. And it's deja vu all over again, because Mack Point is a perfectly legitimate place and less environmentally damaging. It's a practicable alternative, and it's right there across the harbor. And this reminds me of a quote from one of my favorite ecologists, George Schaller, who says, "There are never victories in conservation. If you want to save a species or a habitat, it's a fight forevermore. You can never turn your back." Next slide, please. So I was a whistleblower, and I'm uniquely poised, I think, to help whistleblowers because of my experience at EPA. And pure whistleblowers come to us to blow the whistle on environmental issues or violations of laws like what I did, financial or ethical wrongdoing, and also intimidation or retaliation that these employees experience for trying to do the right thing. Next slide, please. Is there life after blowing the whistle? This is a question that I get frequently from our clients. And the answer is yes, absolutely. I stayed at EPA for 5 years after I blew the whistle before I left. But it's not for the faint of heart. People do not become whistleblowers to get rich or famous. We don't win a lot of money. We're just trying to do the right thing. And whistleblowing can color your entire world. It can affect your marriage, your relationships, your work life, your future work life. Everything about whistleblowing can make your world a different world than it was before you blew the whistle. But often the alternative is worse. Why? Next slide, please. It's because there have been a number of studies done on who these whistleblowers are. There's a real big trade-off between the competing moral values of fairness and loyalty to your agency or your employer. What researchers have found is that abrupt, unethical behavior is more likely to be reported by whistleblowers, which is why we saw a huge uptick when Trump first became president, because there was a lot of unethical behavior in these environmental agencies. Whistleblowers are also more likely to think that something can be done about these unethical breaches, which is not always the case, unfortunately, but they do have hope that things can get better. Next slide, please. So the bottom line is that whistleblowing doesn't mean it's the end of your career. It can open new doors, new windows for you to go through. And oftentimes the type of person who becomes a whistleblower are the type of people who have to. They really have no choice but to try to make the right thing be done. And I liken it to what John Lewis said. It's people getting into good trouble. Whistleblowers who see something that is not right, not fair, or not just, they feel like they have a moral obligation to do something about it. And PEER welcomes these whistleblowers, and we try to do everything we can in our power, not just to help them, but to fix the underlying environmental issue. Thank you. I'd also like to take this opportunity to introduce Paula Dinerstein, who is PEER's general counsel. PEER has had Paula working for us for 17 years now, almost as long as I've been with PEER. And Paula probably knows more about the intricacies of whistleblower law than anybody I know. We would be absolutely lost without her. She's a fabulous general counsel. She works with employees all the time, and she's going to talk to us a little bit now about her experiences at PEER with the whistleblower laws. Paula?
Thank you for that introduction. And can we have the next slide? So I wanted to tell you a little bit more about how PEER works with whistleblowers and what options whistleblowers have. So public employees contact PEER for a variety of reasons. What they're seeing in their jobs is that their agencies are failing to adequately enforce environmental law or implement environmental programs or manage public lands, or that they're suppressing or distorting science. And when people come to us with these kinds of concerns, we actually discourage them from becoming whistleblowers. We try to keep them out of trouble. And if at all possible, to operate anonymously and let PEER try to address the underlying environmental issue. And that's kind of the main difference between an employee who's facing some troubles, considering being a whistleblower, maybe already had some adverse employment actions, going to a private law firm and coming to us. So certainly private law firms have a very important role to play here in defending people who've had bad employment actions taken against them. But they can only help after the person has already gotten in trouble and some action has been taken. And in addition to that, they address the employment issue if the person's been fired or had some disciplinary action taken, et cetera, but not the underlying environmental problem that the person blew the whistle about. So what we try to do is we try to address the underlying environmental problem, ideally before the employee gets in trouble, but if not, afterwards. And we use environmental litigation. PEER brings suits that are not whistleblower suits at all, but are just plain up environmental suits where the person who told us to bring that suit remains anonymous and nobody knows about them. We bring them in the name of peer or other environmental groups that we work with. And we also do advocacy, media, things like filing rulemaking petitions, requests for investigations, and all the while we try to keep the employee who brought us these issues anonymous. So next slide, please. But sometimes the employees who contact us are already in trouble at work, or we can't prevent them from becoming public. And in those cases, there are legal remedies for whistleblower retaliation at the federal level, state, local, and tribal. And one of the things we'll do is advise people as to what remedies will work best for them among all the possibilities. Most employees in these situations can't afford to hire private counsel, so we play a very important role in that we do not charge for our services. The litigation path is far from ideal. Whistleblower litigation is often long and tortuous, and it's very difficult to win these cases. So that goes back to why we try to prevent people from becoming whistleblowers in the first place. But if necessary, we use these tools that are at our disposal and can have some positive results. The remedies in these cases, in addition to the difficulty of actually winning them and pursuing them, the remedies are limited. There are not jury trials in whistleblower cases. This is something the whistleblower advocacy community has been working for many years, and maybe we'll eventually get it. But right now there are no jury trials, and so there are no possibilities of getting $1 million payout like you could with a jury, even if you win. There's just limited remedies under the administrative proceedings we usually work through. So next slide, please. But that doesn't mean that these administrative remedies that we do have are at all useless or not worth pursuing. Whistleblowers can get reinstatement to their position if they've been fired, and they can get back pay for the period in which they were without a job. Because of the disadvantages that whistleblowers face in this type of litigation, we often push for settlements. Sometimes we're able to use media to pressure an agency that is getting exposed as to their wrongdoing and will want to make this go away by having a settlement with the whistleblower. And in those settlements, it's often not workable for the person to go back to the same job because the well has been too poisoned. That's not always true, as Kyla's case illustrated. But often we try to work out a way that the person can get some recompense and continue their career in another way, maybe getting transferred somewhere, maybe with a new agency, or maybe just being set on a path, with a clean record and a good recommendation and some monetary compensation so that they can go ahead and pursue other opportunities for their career. We have had successful cases that not only got a good result for the whistleblower, but that also made precedent that helped future whistleblowers pursue their cases. Next slide, please. So just a few examples of some of our cases that were most important in terms of establishing precedent in whistleblower law, as well as helping the individual we were representing. We represented Teresa Chambers, the former chief of the U.S. Park Police, and after 7 years of litigation, which is also kind of a sad warning of what can happen in terms of how long these cases can take, not usually that long, but she did get her job back after 7 years and collected 7 years of back pay, which was quite a sum. And we also collected attorney's fees in that case, which then we used to finance representing future whistleblowers. Another one is Bob Whitmore, who was an economist with the Occupational Safety and Health Administration. And after winning on appeal, but there was still a remand to kind of clean up a few things in his case, we reached a settlement, which at that time at least was the largest monetary settlement for whistleblower case in history. Another one is Kate Jenkins. She was an EPA chemist who disclosed dangers of the World Trade Center disaster. And in her case, we had the very unusual result that we actually got a default judgment due to EPA's misconduct in the litigation. And that means that the judge rules that because of the misconduct of the agency in the litigation, we win, regardless of the merits of the case. But fortunately, in this case, the judge said, not only do we get a default judgment, but also you would win on the merits. They had no good reason to do what they did to her. And she went back and worked at EPA until she was ready to retire. So all of these cases set important precedent that made it easier for future whistleblowers to prove and win their cases. Next slide, please. So summing it up, we make the best of a flawed system. We, first of all, try to avoid employees becoming whistleblowers and getting in trouble, and still address the environmental issues that concern them. And then if that's not possible, we use the whistleblower litigation system to help get monetary recompense or various ways that they can move on with their careers. So that is all I'm going to say for now. I'd be happy to answer questions during the Q&A period. But for now, we're going to go right on to Monica Mercola, who is our staff counsel, one of our staff counsel. And Monica has a lot of experience working with intake so that when people first contact peer and spill out their problems, she tries to figure out what of some of these tools that we've talked about can be used to help them. And she also has experience with pursuing some of the environmental issues that these people have brought us in ways that don't involve the employee, but try to get the problem solved. So here's Monica.
Thanks, Paula, for the introduction. As you've just heard from Paula, many people come to peer looking for traditional representation for a personnel matter as a result of their environmental whistleblowing. But this is not the only type of public employee we work with. So some intakes come to us not looking really for formal representation, but instead an informal relationship where they're able to provide peer with insider information, and we can then submit Freedom of Information Act requests on their behalf, oftentimes litigating those requests and then publishing that information so that it's in the public domain. Sometimes we do have formal relationships, as Paula went over, and then others come to us looking for assistance with not necessarily their personnel issue, but really just the underlying environmental problem, which can be sometimes resolved through litigation, but also can be resolved through other means. And additionally, peer often will work with employees to disclose this information, which furthers environmental advocacy efforts. Next slide, please. So, for example, peer has worked with various eco champions, as we like to call them. So first, peer has worked with Jonathan Lundgren, whose scientific research was being suppressed. With peer's help, he invoked the US Department of Agriculture's own scientific integrity rules, which say that research cannot be suppressed merely because it is inconvenient for big agriculture and big chemicals. He now has his own research farm in South Dakota and continues to work with peer to highlight the risks of pesticides to bees in the environment. Similarly, Ed Petrovsky witnessed widespread agency indifference to the epidemic of violence perpetrated against land management agency employees. Peer and Ed continue to raise public awareness of the problem of irresponsible off-road vehicle use and organize agency employees to combat it. And lastly, Amy Griffin noticed a pattern of her students getting diagnosed with cancer. With her assistance, Peer has shined the light on toxic chemicals and artificial turf and continues to fight the introduction of artificial turf fields across the United States. And so these are just some examples of the types of people who come to us with insider information, which we are then able to publish and make and shine the light on these issues that they are concerned about. Next slide, please. So as Paula mentioned, there's multiple avenues that Peer takes to resolve the underlying environmental issue. Litigation is not always the best option for public employees. As Paula mentioned, it can be very lengthy, it can be a very challenging process, and it doesn't always address the underlying environmental issue. So Peer then works with public employees to file administrative complaints, submit rulemaking petitions, submit public comments, work with other organizations and nonprofits on advocacy efforts, and as well work on media strategies to, again, shine the light on these types of issues. So I'm going to now provide some examples of the types of actions that Peer takes on behalf of public employees. So next slide, please. So one example of our non-litigation efforts were our comments on lead ammunition. So for many, many years now, Peer has been advocating banning lead ammunition and fishing tackle on public lands as a result of the environmental, ecological, and health concerns regarding lead. We've received many comments from various public employees across multiple agencies about concern regarding the use of lead ammunition and fishing tackle. Only recently has the US Fish and Wildlife Service decided to not allow lead on newly opened national wildlife refuge lands. Peer commented in support of this decision by Fish and Wildlife Service. We continue to work with organizations and public employees to support further actions which reduce the use of lead ammunition and fishing tackle, thereby addressing the underlying environmental issue that many public employees come to us concerned about. Next slide, please. Another example of Peer's advocacy efforts is artificial turf. So we've had multiple, again, public employees come to us very deeply concerned about toxic chemicals within artificial turf. Plastics and pesticides are another example of where these chemicals, PFAS, per and polyfluoroalkyl substances, are used. As a result of Peer's efforts to shine the light on this information and publicize it, Albany County in New York now requires that any facility that sends its waste to the county's treatment plant test for certain PFAS. Peer has also publicly commented on Massachusetts' proposed limits for PFAS in drinking water, and Massachusetts then subsequently passed those drinking water limits. Currently, Peer is opposing the installation of an artificial turf field in a California school. And Peer continues to work to ensure that toxic chemicals are not used in consumer products, pesticides, and other items, and continues to work with governments, municipalities, and public employees to advocate for the banning of toxic chemicals. Next slide, please. Oh, sorry, didn't realize that was the Q&A. I'll just quickly end here saying essentially that, these are multiple examples of many different kinds of issues. So while these issues might seem random, all these issues are brought to us by various public employees who are concerned about the underlying environmental issue, which Peer then takes on. Thank you.
Thank you, Monica. At this time, I now invite participants to enter your questions into the Q&A feature. I will read them out loud and they will be answered live. I also invite all panelists to please come back on camera and we will begin. So while we wait for the Q&A to be populated, we did have a couple of questions. The first one is for Kyla. Kyla, how have you seen the EPA change in its treatment of whistleblowers? Are they any better or worse since you were there?
That's a good question, Helen. My experience has been that they're actually worse than they were when I was there. When I was a whistleblower, I was in Region 1, first of all, not in headquarters, so that was the office in Boston. And I don't think that they had experienced a lot of whistleblowing there. So it was kind of a novel experience for them. It was actually kind of funny because when I filed my complaint, and then the agency decided that they didn't want to fight this out, and they would capitulate to my demands, which were simply that I wanted to be put back on the Sears Island case so I could make the right decision, both legally and scientifically. I wasn't asking for money or anything like that. They actually shook my hand and said, "Don't ever do this again," which is retaliation and is a violation. I reminded them that they can't be saying things like that. So for back then in the 90s, it was a learning experience for both me and I think also for EPA. However, I have a number of EPA clients now. Most notably, we had 5 EPA employees from headquarters come to us from the new chemicals division. And they were alleging a variety of malfeasance really in the new chemicals division, in the risk assessments of new chemicals being put on to the market. And actually Sharon Lerner, when she worked at The Intercept, did a wonderful 10-part series of articles on these 5 whistleblowers, which if anyone's interested, it makes a great read. It's a little horrifying, but they have been treated for the most part very poorly under the Biden administration. So one thing that I've found, because I've been working at Pure through a number of administrations, things sometimes are worse under the Democratic administrations than they are under the Republican administrations, which seems a little counterintuitive because usually Democrats are more concerned about the environment than Republicans are, but the Democrats are a little sneakier about their retaliation and about their political favors. So I guess the answer to your question is that in my experience, EPA has not gotten better about it. And unfortunately, their scientific integrity policy is pretty broken and their whole scientific integrity process. So I would say that things have not improved, unfortunately.
Thank you, Kyla. This next question is for Paula. Paula, do we ever take cases that may not be from public employees, but from someone who has a role that is engaged with government?
I'm sorry, say the last part again. Not public employees, but who?
But from someone who has a role that is engaged with government.
Who has a...
The question is, do we ever take cases that may not be from public employees, but from someone who has a role that is engaged with government?
I'm sorry. Thank you. Usually not. We do sometimes take cases from government contractors, and there actually is a special law protecting government contractor whistleblowers that we have used on occasion. But generally, we do not take cases from people who aren't public employees just because that's not our mission. And, we would get way beyond what our resources would allow if we went beyond that mission. But if somebody comes to us who knows about a problem that's going on in government, we will try to refer them to people who can help, or we will ask them, if they are working with or know any public employees who might want to contact us about that issue, and then we can work with them.
Great, thank you, Paula. Paula, the next question is also for you. Does Peer work with qui-tam or false claim attorneys reporting fraud by the agencies?
We haven't done a lot of that over the years, but we are, not against it. And yes, we have occasionally worked with qui-tam lawyers. It's a very complex and different and difficult area of law that we have not developed expertise in. But we have worked with some other lawyers who do work in that area. And we do advise people, that that's one of the possibilities in terms of actions they can take. And we have a section on our website that explains a little bit about qui-tam litigation.
Thanks, Paula. Kyla, the next question is for you. What is the remedy when a respected government agency suppresses science that they see as bad news for that agency's reputation?
That happens a lot.
Oh, Kyla, go ahead.
That happens a lot. And I think it's really case dependent. It really depends on the specifics of what it is that's being suppressed and which, if it's a region at EPA or in headquarters, or if it's Fish and Wildlife Service, a field office or at headquarters. We do hear about these things a lot. It's the bread and butter of the work that I do, at least. And there's no one size fits all solution for this type of thing. Sometimes we'll use media and we'll just get a story out about the problem. And sometimes that's enough to embarrass the agency in question. Sometimes we use FOIA to get the documents that we know exist because of our whistleblower, and we can then either sue on that or get, again, media attention and shine that bright light onto the issue. So it really depends on what the specifics are and whether the employee who's coming to us with that information wants to be outed or not. So it's very fact specific.
Thank you, Kyla. The next question is for Paula. Paula, Michael has a question. Is there a backlog of whistleblowers coming to Peer, or does Peer have the staff to handle them promptly?
We try to help each person who comes to us, whether they are in a employment problem situation or whether they just want to have an environmental issue addressed and brought to light. That said, obviously we have limited resources and we can't do everything. So if somebody comes to us and we really just don't have the resources to take their case, whether it's an employment case or an environmental case, we will try to find somebody else who can take it for them. And sometimes we have all kinds of arrangements with other groups, like we might find a local employment lawyer, but say, well, if you want to do media on this case, we'll help you with that, or we'll help you with some of the work on the case. And the same thing with environmental cases, where we might try to find another group that is able to take the case and has the resources, but we may play some role as co-counsel or as just sort of along for the ride and helping with the litigation.
Thank you, Paula. The next two questions I think would be best answered by our executive director, Tim Whitehouse. So Tim, if you want to come onto camera, I have two questions for you. The first one is, what role do you think underfunding and understaffing at agencies like the USFW and EPA have to do with their mismanagement?
Yeah, that's a great question. It's an extremely complicated question, but overall, I think it has a lot to do with some of the problems at EPA and U.S. Fish and Wildlife Service. The lack of funding, the lack of proper oversight from Congress, the political football that these agencies have found themselves in the last 20 years has really degraded the quality of the work in those agencies. That being said, there are many situations where the agencies reflexively say, we've done wrong because we don't have a lot of money. And I think that has to be evaluated on an individual case. But I think the question's very good. And I think underfunding is a huge problem, particularly underfunding of science. And we particularly see that at EPA, where scientists have not been properly funded, and a lot of this work is being outsourced to the private sector.
Thank you, Tim. The next question is also for you. Where are peer and EPA labor people on getting a hearing in Congress on the broken scientific integrity program at EPA and the terrible model scientific integrity program OSTP has just published?
Great. Yeah, thank you. Great question, Bill. I know Bill's been involved in EPA's union for many years and has been a strong advocate for scientific integrity policies being strengthened at EPA. Just a little background for people on this webinar that may not be familiar with the issue. OSTP is the White House's sort of science office, and they undertook a 2-year effort to improve the agency's scientific integrity policies after the Trump administration left office. The Trump administration used the existing scientific integrity policies of different agencies that were developed with good intentions under the Obama administration, really to persecute scientists and to move them around and get them out of their positions. And it showed how weak those policies actually were, because the Trump administration could say we were following the policies when we were doing this. And so the Biden administration undertook an effort to strengthen those, but as is often the case, there were some improvements in it, but really some backward movement by the Biden administration in proposing these policies. Peer, along with EPA unions, a number of scientific groups, as well as nonprofit environmental groups, strongly objected to these new proposals by the Biden administration. And we were trying to work with Congress to get some sort of oversight. So where this stands now, as far as I know, is OSTP, the White House science arm, has received our comments and comments from other groups asking them to change their model policy. We expect the final policies to start coming out this fall. We do not know whether they will listen to us. And some of the Senate staffers we were working with that are concerned about these policies have gone silent. It's a really hard time to work with Congress right now. But I think, Bill, that's a good reminder for us to keep making those phone calls back to the Senate, because I do think that would help the Biden administration strengthen these policies.
Thank you, Tim.
And I don't know if in those last two questions, if anyone else on the panel has anything to add to them. I know our staff has been very involved in both staffing issues and scientific integrity policy issues.
Okay, thank you, Tim. Kyla, the next question's for you. Are we helping with environmental toxicity cases like electromagnetic fields, electric currents, radio frequencies, or the invasion of telecoms contaminating natural environments?
One thing you should know is that Peer is very client-driven. So we don't go out and look for cases. We wait for clients to bring them to us. So Paula has worked, I think I'm going to shunt this one to Paula. She's worked with the cell towers in national parks issue, and she can address that because that was brought to us, that and also flyovers. But we have not, to my knowledge, been brought a EMF case, but Paula or Monica, feel free to correct me if I'm wrong.
Yeah, not that I know of, but we've been very active in the issue of cell towers in national parks. And, we have done a lot of FOIA work trying to understand where these cell towers are, what the National Park Service is doing about them, and opposing them, putting a lot press releases about what's going on there. We don't believe that the national parks need cell coverage in the backcountry. That's where people go to get away from all that sort of thing, and to have a situation that is quiet and not electronic. So we've been working and advocating on that for quite a while. It's a difficult thing because the Park Service is not even very transparent about what's going on and what they're allowing to happen and what they're giving these telecoms the right to do in the parks. So we've been working, trying to uncover it and expose it and address it.
Thanks, Paula. Paula, the next question is also for you. The question is, do we work with folks who already have an attorney?
We sometimes do. If somebody calls us who already has an attorney, we let them know that we can't do anything without their attorney's permission, and working with their attorney. And if the person wants to try to do that, we will contact the attorney and see whether and to what extent they want to work together. And as I mentioned earlier, as a way of sort of stretching our resources and being able to help more people, sometimes we will work with other attorneys, either that the employee already had when they came to us or that we find who can do a lot of the legal work in a case while, we will be there to help out, maybe to be the person, the organization that takes the issue to the media if that's appropriate, always, again, only if the other attorney agrees, or do FOIA requests and FOIA litigation around it, or other things that could be helpful in the case to that other attorney.
Great, thank you, Paula. The next question that we have here is about question from Keith. Can the presenters speak to the persistent culture of harassment and discrimination at the Department of Interior and the National Park Service, and how that generally chills employees from speaking out and or whistleblowing?
I can offer a thought on that, and Monica, you may want to jump in too, some of your thoughts. So the National Park Service is a difficult place for many people to work, including but not exclusively women. And it's consistently rated one of the worst places to work in the federal government through these Office of Personnel Management surveys, which they do for all the federal agencies. And at the National Park Service in 2017, there was an employee survey done where a very high percentage, I may have my number wrong, but maybe like 35%, is really outstanding high number of people said they had experienced harassment and retaliation from their management in the last 12 months. And as a consequence of that, the leadership at the National Park Service undertook a process which they promised to be very transparent, where they had a number of listening sessions. They brought in outside consultants to run these sessions, and they did surveys of employees about their work-life culture in the National Park Service. And they created a report called the Voices Report, which they had promised to release to the public. That report was pretty damning about the culture at many places in the National Park Service and how difficult it was for employees to work. Needless to say, that report was never released until it was given to us 3 years after it was finalized. Someone anonymously gave it to us and said to Pierre, maybe you ought to release this report. And we did. Since then, through these employee surveys, through the Office of Personnel Management, it seems the ratings of the National Park Service have actually gotten worse. And so and I know there are people on this webinar who have worked at the National Park Service, and what I understand is there's a real problem of harassment and discrimination in certain parts of the National Park Service. Obviously, every park is different. Every park superintendent is different, but it's a significant problem, and it does chill employees from speaking out. Paula or Monica, I don't know if you have anything to add to that, but that's sort of an overview of our involvement there.
Thank you, Tim. Tim, the next question is also for you. How can the public support our mission beyond donating?
Thank you. I think, and again, anyone else on the panel that wants to jump in, I think what's really important for peer to do a better job. We're always so busy, so but one thing that's really important for us to do is to make connections in different communities. And we are always delighted when community groups reach out to us and ask us to speak at an event. We're always willing to talk about what peer does. So if you're a member of a community group and you think that peer might be able to provide a good discussion group or a good topic to discuss, not only on whistleblowing, but whether it's climate change or chemicals or preserving public lands, I think that's something that we could do, and that the public could help spread the word about what peer does. The other thing I think that is important is, and I think we learned this during the Trump administration, the public did, is as environmentalists, we often focus on laws and standards. So is the law or standard good? And environmental groups, peer included, spend a lot of time arguing for stricter standards. But I think what peer looks at and what a few other groups look at is issues of governance. And so if you're a community member and you're working with environmental groups, always, try and look through the lens of governance. Not only are these laws good, but do the government agencies have the resources? Do the civil servants have the freedom they need to do their work? And so that's another way that the public can help sort of peer's overall mission. Thank you.
Thanks, Tim. Question for the panelists. I'm not sure who's best to answer, so please jump in. Question from Annette. Has there been a whistleblower exposing GMO pesticides or GMO seeds?
Well, I can give one answer to that, which is that we had a long series of cases having to do with the use of GMOs on national wildlife refuges. And a lot of people don't know this, but a lot of national wildlife refuges will have agreements where they sort of lease part of their land to farmers. And I think this is mostly done if the refuge is in a farming region. It seems friendlier to the people around them to do this. But they were allowing these farmers to use GMOs in their farming on the refuge, which is obviously not the best thing for the wildlife on the refuge. And often part of the reason they would claim they were doing this was that, let's say the farmer was growing corn or soybeans, and they would say, well, part of the agreement is that the farmer's going to leave 20% of their crop for the birds to come eat. So it's actually benefiting the wildlife. However, if the crop is GMO, it's very questionable whether that wildlife should be eating it. So we had a series of cases that, this was during the Obama administration, that ultimately culminated in a Fish and Wildlife Service policy saying that they weren't going to have GMOs on refuges. And then that was reversed by the Trump administration. And we have tried to get it back. However, I don't think that even though the policy was reversed on paper by the Trump administration, that refuges are actually growing GMO crops again. So that's one way we've been involved in that. There may be others if other people have things to say about that. But again, it all depends on what public employees bring us. that case was originated by a biologist on one of the refuges who had this great project where she was returning an area to native plants and native wildlife. And they came in and said, sorry, we're going to, have this area be farmed with GMO crops. And so she was obviously very upset and came to PEER, and it started this whole train of a series of cases that we brought about that.
Thank you, Paula. We do have a great question here from Jim I want to get to. He said, you did a good job on exposing the lack of assessments and poor conditions on grazing allotments by the BLM. However, the BLM has not shown significant improvement. What needs to be done next? Who'd like to take that?
Yeah, let me see. I'll get my camera back on. So yes, if you send us an email, Jim, we can get back to you on that. I know Chandra Rosenthal is spearheading that effort. So for those on the webinar, BLM, does a really poor job assessing land health, which they're supposed to do by law. And they are changing the way they're doing their land health standards. However, there's significant issues with the way they're doing that. So we can follow up with you, Jim, in more detail.
Last question here. Thank you. Go ahead, Paula.
Sorry. Just to add to that, I mean, generically, there are so many issues where you just have to keep fighting for years and years. And this is one of them. We've been working on various grazing issues probably ever since PEER has existed, and will continue to do so. So and it doesn't mean that, sometimes you do get a victory after a long time. You can't give up.
Thanks, Paula. Last question, and then we'll have Tim wrap up for us. Who are the champions of Congress for scientific integrity and whistleblowers?
Great question. And
I
Paula,
can name two.
Yeah, go ahead, Kyla. I was going to say something, but go ahead, Kyla.
Ro Khanna and Diana DeJet from Colorado. Both of them weighed in on our EPA whistleblowers. We also have a number of congressional allies on our PFAS issues and PFAS whistleblowing cases with the firefighters, with PFAS in plastic containers. So there have been quite a number of those. Dan Kildee, Ed Markey, but Ro Khanna and Diana DeJet both specifically helped us a lot with our whistleblowers and the whole scientific integrity thing. But Tim, go ahead if you have others.
Yeah, and Dick Durbin has been strong on these issues. The problem is right now is the Senate in particular is so tribal. I hate to use that word, that they're focused on these issues that are not these sort of oversight issues that they need to be involved in. There are very few people doing oversight the way it was done 20 or 30 years ago. And so we're really missing those really active champions, whether Democratic or Republican, in Congress that kind of look at the details of how government works and try and have things work better.
So just to add to that, traditionally, Senator Grassley has been the champion of all kinds of whistleblower legislation. And, he's a Republican. There's a lot of things maybe we don't agree with him on, but the whistleblower community, which we participate in, has always tried to keep it bipartisan and keep that whistleblowing as a bipartisan issue, that we can get champions from both parties. And Senator Grassley probably won't be there that much longer, but he's always been the champion of whistleblower legislation.
Thank you, Paula. Thank you to all the panelists. We are at the top of the hour. So Tim, if you can bring us to a close.
Yeah, thank you. I know there's some questions we didn't get to, so if anyone wants to reach out to any of us individually, please do. We're happy to continue this discussion one-on-one or through email. So, drop us an email or pick up the phone. I came to Peer, 4 years ago. I had crossed paths with different whistleblowers, but hadn't been involved in the whistleblower community or knew a lot about whistleblowing. And I think over the last 4 years, I've really learned how important whistleblowers are to the vitality of our civil service and to our democracy. And we've learned sort of over the last 4, 6, 10 years that we really need people who are willing to stand up and speak out against wrongdoing. And we need to be assured that we can reward and make those people feel safe and defend them. So thank you for being here. I hope we can continue this discussion. I want to thank you, Monica, Paula, and Kyla, for all your hard work. And I hope we can continue this conversation with everyone that joined us today. Thank you.